Ethics 101. Pay attention. In the last video, we talked about engagement in business, and that was fun. Now we're looking at Rule 8, which talks about lawyers and salaried employment. Now, this rule is one of the first rules that leaves you scratching your head. Why is there a prohibition on legal practitioners in salaried employment in the first place? Why can't they appear in court? Let's look at the highlights of this rule. A lawyer in salaried employment cannot appear in a court or tribunal on behalf of his employer. You may ask, then why are we giving him money? That's why I'm here, to explain this madness. Firstly, the RPC only states that he can't appear in court on behalf of his employer. It doesn't state that he can't appear for anyone else. Secondly, the RPC didn't state that the lawyer couldn't be a legal consultant or a solicitor for his employer. It just focuses on the advocacy part and other things related to advocacy. This means that he can't prepare, sign, frank documents and instruments that may eventually relate to court proceedings, unless the rules provide otherwise. Another point is that a director of a company can't appear in court on behalf of the company as an advocate. The fact that he's a non-executive director is irrelevant. But remember, nothing stops him from being a solicitor or legal consultant. He just can't advocate. Also, a lawyer in full-time salaried employment may represent his employer as an officer or agent in some instances. But the lawyer won't wear his robe. Let me illustrate this. Imagine that there's a case between some random person and the Federal Mortgage Bank of Nigeria. And then we have James, a non-executive director of the bank, who also happens to be a legal practitioner. Now, on behalf of the Federal Mortgage Bank of Nigeria, James comes to court with his legal team, as he's a natural person, but the bank, being a legal personality, would still need an agent apart from the legal team to represent the bank. This means that if James wants to be in the proceedings, he cannot be robed. This signifies to the courts that he's not coming as a legal practitioner, but as an agent of the bank. Another point to take note of is that a legal practitioner who is also an officer can be a judge advocate in a court-martial. So in that case, he's appearing before a court-martial because he's appointed and constitutes the court-martial, not necessarily because he wants to be there. It's important to note that in this case, he's discharging his duties in the capacity of a military officer, not a legal practitioner. So I've just told you that lawyers who are in full-time salaried employment can't appear in court for their employers, but I didn't tell you why. The reason is because the legal profession has a lot of lawyers who need work, and if the employers are allowed to utilize their in-house lawyers for everything, that is, advocacy and legal consultancy, there would be a shortage of work which could ruin the lawyer work economy. It also has the potential of shortchanging the lawyer in salaried employment, as his remuneration is no longer seen as general or special retainers, but is tied to his salary that covers all legal work, which may not be fair compensation. This is against Rule 49 in RPC that talks about retainers, and we'll get to that later in the series. And with that, we've come to the end of Rule 8. Now we're going to focus on Rule 9, which talks about practicing fees. Thank you very much for watching, guys, and remember, stay lawful, stay informed.